Hello everyone, I'm an engineer and a law graduate, and I welcome you to my channel where law meets logic and learning becomes easy. Welcome back to part 4 of our environmental law series. In this video, we'll be diving deeper into two powerful legal tools that play a crucial role in protecting our environment in India: the Water Prevention and Control of Pollution Act 1974, National Green Tribunal NGT powers and functions, and international treaties related to environmental protection. Whether you're preparing for exams or just eager to understand how the law empowers citizens and authorities to fight pollution and safeguard nature, you're in the right place. Let's continue where we left off. 8. The Water Prevention and Control of Pollution Act 1974. The introduction. The Water Prevention and Control of Pollution Act 1974, hereinafter the Water Act, is one of the earliest environmental legislations enacted in India to specifically address water pollution and protect the water bodies from contamination. The act was passed soon after India's participation in the United Nations Conference on the Human Environment, Stockholm, 1972, which emphasized the need for environmental conservation and pollution control. It provides the legal framework for prevention and control of water pollution and for maintaining or restoring the wholesomeness of water. So, objectives of the Water Act: to prevent, control, and abate water pollution, to establish Central Pollution Control Board (CPCB) and State Pollution Control Boards (SPCBs) with powers to implement water pollution control measures, to regulate and monitor the discharge of pollutants into water bodies, to promote sustainable use and conservation of water resources. The 8 definitions and scope. Water pollution, Section 2G. Any contamination of water or alteration of its physical, chemical, or biological properties, making it harmful for public health or other uses. Pollution, Section 2F. The presence of any pollutants in water. Effluent, Section 2E. Any liquid, gaseous, or solid substance discharged into water. Sewage, Section 2L. Wastewater from residential, commercial, or industrial sources. The Act applies to all waters in India, including rivers, lakes, wells, reservoirs, tanks, canals, and other water bodies. IV. Institutional framework. 1. Central Pollution Control Board (CPCB), constituted under Section 3. Functions include advising the central government on water pollution control, coordinating activities of state boards, establishing standards, conducting research, and disseminating information. 2. State Pollution Control Boards (SPCBs), constituted under Section 4, responsible for implementation of the Act within the state, perform functions like inspecting water bodies, enforcing standards, granting consents, and initiating prosecutions. V. Powers and functions of boards. Powers of CPCB, Section 17, advising central government, coordinating activities of state boards, collection and dissemination of information related to water pollution, research and development in pollution control techniques, setting water quality standards. Powers of SPCBs, Section 18, planning and executing programs for water pollution prevention, inspecting sewage or effluent treatment plants, establishing effluent standards, granting or revoking consents for discharge of pollutants, suing polluters for violations, visa prevention and control mechanisms, and consent of the board. Section 25. No person shall discharge sewage or trade effluent into any water body without prior consent of the state board. Consent may specify conditions to ensure pollution control. Consent can be revoked or refused in case of non-compliance. 2. Establishment of standards. Section 24. CPCB and SPCBs have the power to establish standards for the quality of water for different uses, such as drinking, agriculture, or industrial purposes. Also prescribe standards for effluents and discharge limits. 3. Water pollution control areas. Section 23. State governments, in consultation with SPCBs, can declare certain areas as water pollution control areas. Industries located in such areas must comply with stricter controls. 7. Inspection and enforcement. 1. Entry and inspection. Section 26. Authorized officers can enter premises to inspect facilities, collect samples of water, sewage, or effluent. They can examine books and documents related to discharge. 2. Power to issue directions. Section 33A. SPCBs or CPCB can issue directions for the closure, prohibition, or regulation of any industry, operation, or process causing water pollution. Failure to comply can result in penalties and imprisonment. 8. Penalties and legal provisions. 1. Section 33. Punishment for any person who violates the provisions regarding discharge of pollutants without consent or discharges in excess of prescribed standards. Imprisonment up to 6 months or fine up to Rs 10,000 or both. For continued offense, additional fine up to R 1,000 per day. 2. Section 35 provides protection to persons acting under the Act from legal proceedings, ensuring enforcement officers can perform duties without harassment. 3. Section 36 penalties for failure to furnish information, false information, or obstruction of officers. My judicial interpretations. 1 MC Mehta Vet Union of India Ganga Pollution Case, IR 1988 SC 1037. The Supreme Court issued directions to control pollution of the river Ganga, recognizing the right to clean water as part of the fundamental right under Article 21, Right to Life. Directed industries and municipalities to install proper effluent treatment plants, ETPs. Ordered closure of polluting industries along the river. The 2. Vellore Citizens Welfare Forum v. Union of India, 1996, 5 SCC 647. The Supreme Court adopted the precautionary principle and polluter pays principle, directed strict enforcement of water pollution control laws. The case emphasized sustainable development, balancing environmental protection with economic growth. 3. Indian Council for Environlegal Action with the Union of India, 1996, 3 SCC 212. Held industries responsible for polluting groundwater and surface water. Industries were ordered to pay compensation to affected persons. X. Relationship with other environmental laws. The Water Act is complemented by the Environment Protection Act, 1986, which empowers the central government to take stricter measures. The Air Act, 1981, works in tandem for integrated pollution control. The Factories Act, 1948, also contains provisions related to effluent discharge and water use. ICSE, challenges in implementation. 1. Inadequate infrastructure. Many states lack adequate sewage treatment plants. Industrial effluent treatment is often insufficient. 2. Monitoring and enforcement. SPCBs suffer from lack of manpower and resources. Illegal discharge and non-compliance are widespread. 3. Urbanization and industrial growth. Rapid industrialization has increased water pollution. Agricultural runoff and untreated sewage add to contamination. Dute, recent initiatives. 1. National Water Quality Monitoring Program. CPCB conducts regular monitoring of rivers and lakes. Generates data for policy and public awareness. 2. Namamikange Programme. A flagship government initiative to clean and conserve the river Ganga. Includes sewage treatment infrastructure, river surface cleaning, and afforestation. 3. Conclusion. The Water, Prevention and Control of Pollution. Act 1974 forms the foundation for India's legal approach to combating water pollution. It establishes a clear institutional framework for controlling pollution from industrial and municipal sources through consent mechanisms, standards, and enforcement powers. Despite its strong legal framework, water pollution remains a major challenge due to enforcement gaps, resource constraints, and increasing demand from growing population and industries. The judiciary has played a pivotal role in strengthening enforcement through landmark judgments recognizing the right to clean water as part of the fundamental right to life under Article 21. For effective water pollution control, integrated efforts involving law enforcement, technological improvements in treatment, public awareness, and community participation are essential. 9. National Green Tribunal NGT powers and functions. The introduction. The National Green Tribunal NGT is a specialized environmental court established by the Government of India in 2010 to expedite the disposal of cases related to environmental protection and conservation of forests and natural resources. The NGT was constituted under the National Green Tribunal Act, 2010, NGT Act, following the recommendations of the Justice K.T. Thomas Committee and the need for a specialized forum due to increasing environmental litigation and the complex nature of environmental disputes. 2. Objectives and purpose. provide speedy and effective justice in environmental cases, ensure implementation of environmental laws, reduce the burden of environmental cases on regular courts, provide a platform for public interest litigation (PIL) relating to environmental matters, promote the principles of sustainable development, precautionary principle, and polluter pays principle. 3. Constitutional and legal basis. The NGT is a statutory body created by the National Green Tribunal Act 2010. It draws powers from multiple environmental statutes, including Environment Protection Act 1986, Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act 1981, the Forest Conservation Act 1980, the Wildlife Protection Act 1972. The NGT applies the principles enshrined under Article 48A and 51AG of the Constitution. Article 48A, Directive to the State to Protect and Improve the Environment. Article 51AG, Fundamental Duty of Citizens to Protect the Environment. IV, Composition and Structure. The tribunal consists of a chairperson, judicial members, and expert members. The chairperson is a retired Supreme Court judge. Members are selected from the judiciary and environmental science fields, ensuring a balance of legal and technical expertise. The tribunal sits in benches in different parts of the country, principal bench at New Delhi, and regional benches at Bhopal, Pune, Chennai, Kolkata, and others. V. Jurisdiction and scope. 1. Original jurisdiction, Section 14 of the NGT Act. The NGT has jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to environment, is involved. These include enforcement of environmental laws, disputes involving water, air, land pollution, forest conservation, biodiversity, hazardous waste, and other environmental issues, cases involving approval and compliance with environmental clearances, appeals against orders or decisions of pollution control boards. 2. Appellate jurisdiction. The NGT hears appeals against orders passed by state pollution control boards, Central Pollution Control Board, other authorities under environmental laws. 3. Exclusion of civil courts. Civil courts are excluded from entertaining matters that fall within the NGT's jurisdiction, except writ petitions under Article 226 and 32 of the Constitution. Powers of the National Green Tribunal. The NGT is vested with wide powers akin to a civil court for the purpose of conducting proceedings efficiently, summoning and enforcing attendance of witnesses, discovery and production of documents, receiving evidence on affidavits, issuing commissions for examination of witnesses, granting interim relief or injunctions to prevent environmental damage, reviewing its own decisions, punishing for contempt of the tribunal, imposing penalties and compensation for environmental damage, silent procedure and disposal of cases. The NGT follows simplified procedures and is not bound by the strict rules of evidence or civil procedure. The focus is on speedy disposal with minimum technicalities. It encourages mediation and settlement of disputes. The tribunal maintains transparency and has a system for public hearings and taking inputs from affected communities. Powers to impose compensation and penalties. The NGT can impose monetary compensation on polluters based on the polluter pays principle. It can order restoration of damaged environment by directing polluters to undertake remedial measures. Penalties may be imposed for noncompliance with orders, illegal construction or activity causing environmental damage, failure to follow pollution control measures, NIGU, landmark judgments and impact. Yen, Vellore Citizens Welfare Forum Viz Union of India, 1996. Although predating the NGT, the Supreme Court emphasized the need for a dedicated forum for environmental justice, later realized in the form of the NGT. 2. Rural Litigation and Entitlement Kendra v. State of Uttar Pradesh, 1985. Emphasized the precautionary principle and sustainable development, principles now applied by the NGT. 3. NGT's order in Delhi vehicular pollution cases imposed strict vehicle emission norms. Directed use of cleaner fuels like CNG. Fatul Ganga pollution cases ordered construction of sewage treatment plants. Directed strict monitoring of industrial discharges. Public Interest Litigation, PIL, and Environmental Justice. The NGT has been a significant platform for appeals related to environmental protection. It allows individuals, NGOs, and communities to file complaints without the traditional locus standi restrictions, enables vulnerable groups and marginalized communities to seek redressal for environmental harms. Exit relationship with other courts. The NGT's decisions are appealable to the Supreme Court within 90 days. It has reduced the burden on the Supreme Court and High Courts by specializing in environmental issues. It operates parallel to but independent of the traditional judiciary. Tuesday, challenges faced. Backlog of cases due to increasing environmental litigation, need for greater regional benches to reduce burden on Delhi and other centers, sometimes accused of delays and procedural inefficiencies. Enforcement of its orders still requires effective coordination with executive agencies. Threat, recent reforms and developments. The government is considering reforms to strengthen NGT's independence, proposal for additional benches and regional offices, increasing use of technology for virtual hearings, greater focus on climate change litigation and sustainable development goals (SDGs). 14. Conclusion. The National Green Tribunal represents a milestone in India's environmental jurisprudence, bringing specialized, speedy, and effective justice in matters related to environment and forest protection. Its powers and functions empower it to enforce complex environmental laws and principles while balancing development and ecological sustainability. Despite some challenges, the NGT remains a crucial forum for environmental justice, safeguarding citizens' constitutional right to a healthy environment and pushing India towards greener, cleaner development. 10. International treaties related to environmental protection. The introduction. Environmental problems like climate change, biodiversity loss, pollution, and ozone depletion are global in nature and transcend national borders. No single country can tackle these challenges alone. Consequently, international cooperation through treaties, conventions, and protocols has become essential for global environmental governance. International environmental treaties are binding agreements between countries aimed at addressing specific environmental issues, setting standards, and ensuring collective responsibility for the protection and sustainable management of natural resources. 2. Importance of international environmental treaties. Foster global cooperation to address environmental problems affecting multiple countries. Promote shared responsibility for conservation and sustainable development. Provide frameworks for monitoring, reporting, and enforcement. Enable technology transfer and financial assistance to developing countries. Create legal obligations that guide national policies and legislation. 3. The major international environmental treaties. 1. The Stockholm Declaration, 1972. Adopted at the United Nations Conference on the Human Environment, Stockholm, marked the beginning of global environmental diplomacy. Established 26 principles emphasizing the right to a healthy environment and the duty to protect natural resources. Led to the creation of the United Nations Environment Programme, UNEP. 2. The Montreal Protocol on Substances that Deplete the Ozone Layer, 1987. Objective: to phase out production and consumption of ozone-depleting substances, ODS, like CFCs. Highly successful due to clear targets, timelines, and scientific monitoring. Resulted in the recovery of the ozone layer. India is a party and committed to phasing out ODS. 3. The Rio Declaration and Agenda, 21, 1992. Adopted at the United Nations Conference on Environment and Development, UNCED, in Rio de Janeiro. Rio Declaration laid down 27 principles including sustainable development, precautionary principle, and public participation. Agenda 21 is a comprehensive action plan for global sustainable development. 4. Convention on Biological Diversity, CBD, 1992. Goals: conservation of biological diversity, sustainable use of its components, fair and equitable sharing of benefits arising from genetic resources. India is a party and has enacted the Biological Diversity Act 2002 to implement its provisions. Establishes mechanisms for protected areas, access and benefit sharing, and biodiversity action plans. 5. United Nations Framework Convention on Climate Change, UNFCCC, 1992. Framework for International Cooperation to Combat Climate Change. Establishes principles of common but differentiated responsibilities. sets up mechanisms for reporting emissions, adaptation, and technology transfer, led to subsequent protocols like Kyoto Protocol and Paris Agreement. 6. Kyoto Protocol 1997. First legally binding treaty under UNFCCC setting emission reduction targets for developed countries. India ratified it but was not bound by reduction targets as a developing country. Introduced mechanisms like Clean Development Mechanism (CDM) for carbon trading. 7. Paris Agreement 2015, successor to Kyoto Protocol. Goal to limit global warming to well below 2 degrees C, preferably to 1.5 degrees C above pre-industrial levels. Requires countries to submit nationally determined contributions (NDCs) for emission reductions. Emphasizes climate finance, adaptation, and transparency. 8. Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and Their Disposal, 1989. Controls the movement and disposal of hazardous wastes internationally. Seeks to reduce hazardous waste generation and ensure environmentally sound disposal. Important for regulating e-waste and chemical wastes. 9. Ramsar Convention on Wetlands, 1971. Provides framework for conservation and wise use of wetlands of international importance. India has several Ramsar sites protected under this convention. 10. Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES, 1973. Regulates international trade of endangered species to prevent their exploitation. Ensures trade does not threaten species survival. India enforces this through Wildlife Protection Act, 1972. Evetu India's role in international environmental treaties. India is a signatory or party to most major international environmental treaties, has enacted domestic laws and policies to implement treaty obligations, actively participates in global environmental negotiations and forums, strives to balance development needs with environmental protection. India emphasizes equity, common but differentiated responsibilities, and financial assistance for developing countries, with principles embedded in international treaties. 1. Precautionary principle. Action to prevent environmental harm even when scientific certainty is lacking. Seen in Rio Declaration Principle 15. Do polluter pays principle. Those responsible for pollution must bear the costs of managing it. Enforced in multiple treaties and reflected in national laws. 3. Sustainable development. Development that meets present needs without compromising future generations. Central theme of Rio Declaration and Agenda 21. 4. Common but differentiated responsibilities, CBDR. Acknowledges differing capabilities and responsibilities of developed and developing countries. Seen in UNFCCC and Paris Agreement. V. Enforcement and compliance. Many treaties have monitoring bodies and mechanisms for reporting. Some provide for dispute resolution and sanctions. Compliance often relies on peer pressure, transparency, and capacity building. Countries may face diplomatic or trade consequences for non-compliance. 7th, challenges in international environmental treaties. Conflicting economic and development interest. Lack of binding enforcement in some treaties. Unequal capacities of countries to implement obligations. Political will and prioritization vary across nations. Issues of sovereignty and national interest. With a conclusion, international environmental treaties play a critical role in addressing global environmental challenges by creating a cooperative framework that individual nations alone cannot achieve. India's active engagement in these treaties demonstrates its commitment to global environmental governance while balancing its developmental priorities. The success of these treaties depends on effective implementation, political will, and international solidarity to ensure a sustainable and healthy planet for current and future generations. In this series, I'll be covering important questions from each subject, semester-wise, explained in simple, structured, and student-friendly language. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. Please like, share, and subscribe. Thank you for watching.